All rise, veuillez vous lever. The International Criminal Court is now in session. Lord John to Court Panel International at Huet. Please be seated. Veuillez vous asseoir.
L'audience est ouverte. Bonjour à toutes et à tous. Madame la greffière d'audience, veuillez appeler l'affaire, s'il vous plaît.
Good morning, Mr. President, Your Honors. This is the situation in the Republic of Mali in the case of the prosecutor versus Al-Hassan Abdul Aziz Mohammed Mahmoud. Case reference ICC 0112-0118, and for the record, we are in open session.
Merci beaucoup, Madame la greffière. Je souhaite la bienvenue à tous ceux qui sont présents dans cette salle d'audience, naturellement à M. Hassan, qui est présent, et aussi à toutes les personnes qui sont dans la galerie du public et à toutes les personnes qui nous suivent au loin. Comme tout le matin, je voudrais commencer avec les présentations de différentes équipes, en commençant avec le bureau du procureur. Monsieur le procureur du Tertre, vous avez la parole, s'il vous plaît. Veuillez vous présenter, ainsi que le membre de votre équipe.
Bonjour Monsieur le Président, je vous remercie. Bonjour Madame la Juge, bonjour Madame la Juge. Le bureau du procureur ce matin est représenté par Monsieur Moussa Alafi, à l'arrière, Penwede Yanogo, également à l'arrière, Sandra Shutters, Marie-Jeanne Sardachti, Caroline Leroy, Lucio Garcia, Yaya Yamaguchi et moi-même, Gilles Dutertre. Je vous remercie et j'en profite pour saluer tout le monde à l'intérieur et à l'extérieur de cette salle, y compris notre public au Mali.
Merci beaucoup, Monsieur le procureur. Je me tourne vers la défense. Maître Taylor, veuillez vous présenter, ainsi que les membres de votre équipe, s'il vous plaît.
Thank you very much, Mr. President, Your Honours. The defence for Mr. Al-Hassan is represented today by Dr. Felicity Gary, to my right, and Maitre Melissa Boyer-Lucier, to my left. And going around this way, we have Maitre Alka Pradan, we have Maitre Leila Abid, we have Maitre Mohamed Youssef, we have Professor Mohamed Badar, we have Mr. Maulud Al-Ansari, we have Maitre Kelsey Ryan, and we have Ms. Brianna Dyer. Thank you and myself, Melinda Taylor. Thank you very much. And good morning to everyone in and around the courtroom.
Merci beaucoup, Maître Taylor. Enfin, je me tourne vers les représentants légaux des victimes. Maître Nsita, veuillez vous présenter, ainsi que le membre de votre équipe, s'il vous plaît.
Bonjour, Monsieur le juge président, honorables mesdames les juges. Les victimes sont représentées à l'audience de ce jour par Madame Priske Bieke Dipanga, par Andrés Felipe Arias Morales, par Maître Julie Goffin, par mon estimé confrère Maître Mayumbo et par notre cher confrère Maître Sédou Doumbia qui suit les audiences depuis Bamako et évidemment par moi-même. Mais je voulais déjà signaler à la Chambre que suite à une forte pluie à Bamako, il y a deux autres membres de l'équipe qui sont en chemin et qui cherchent tous les chemins possibles pour atteindre la salle d'audience. Donc, ils seront dans la salle d'audience un peu avec de retard. Je vous remercie.
Merci beaucoup, Maître Nsita. La Chambre vous remercie naturellement pour cette clarification au sujet de vos confrères qui sont au Mali. Aujourd'hui, c'est notre troisième jour consacré à l'audition des conclusions finales des parties et participants. Ce matin, nous allons entendre les plaidoiries de la défense. La suite est certainement la fin. Alors, sans plus tarder, je donne la parole à Maître Taylor. Maître Taylor, vous avez la parole, s'il vous plaît.
Bon matin, Monsieur le Président, Mesdames les juges, avec votre permission, je vais m'adresser. Ce sera moi qui s'adresserai à vous. Je traiterai donc des allégations de mariage forcé comme autre acte inhumain, d'esclavage sexuel et de viol, et des viols en détention. J'aborderai les 4 sujets suivants. Premièrement, l'absence de preuves hors de tout doute raisonnable qu'il y a eu des mariages forcés qui faisaient partie d'un dessein commun. Deuxièmement, l'absence de preuves hors de tout doute raisonnable que M. Al-Hassan avait la connaissance que les 10 mariages étaient forcés et l'absence de preuves qu'il y ait contribué. Troisièmement, le fait que l'environnement n'en était pas un coercitif et que Ansardine n'a pas profité d'un tel environnement. Enfin, le fait qu'il n'existe pas de preuves hors de tout doute raisonnable permettant de conclure qu'il y a eu des viols en détention dans un dessein commun et que M. Al-Hassan en avait la connaissance et qu'il y a contribué. Tout d'abord, la défense soumet que le procureur n'a pas établi que le groupe était animé par un dessein commun ayant mené à forcer les femmes à se marier. Au soutien de cette théorie, le procureur allègue que Yad Aghali a affirmé qu'il donnerait des femmes aux individus qui joindraient le groupe. Cette allégation provient d'un individu capturé à Aguelhoc au début de l'année 2012, alors que celui-ci aurait entendu de la part d'un déserteur ayant joint Ansardine que Yad Aghali donnait des femmes au groupe. Il s'agit en fait de oui-dire, qui n'est pas corroboré, qui se situe hors de la période temporelle des charges, hors du champ géographique, et ne présente pas de lien avec ce qui s'est passé à Tombouctou. Dans les circonstances entourant cet événement, et par la fonction occupée par cette personne, ces paroles ne peuvent revêtir aucune crédibilité ni fiabilité. Contrairement à ce que soutient le procureur, des témoins ont expliqué que les membres du groupe ont été éduqués à l'approche malikite du mariage, qui nécessite l'obtention du consentement de l'épouse ou du gardien, selon le cas. Les membres devaient respecter les traditions locales. C'est ce qu'a expliqué le témoin du procureur P150 au transcrit 103 à la page 11, ainsi que le témoin de la défense D202 au transcrit 203 à la page 18. Le témoin de la défense D528 a également témoigné à l'effet que le groupe n'avait pas mis de pression ou encouragé ses membres à se marier. Transcrit d'audience 189 à la page 8. Il n'a donc jamais été question de prendre des femmes comme épouses sans leur consentement. Par la suite, l'existence de mariages forcés à Tombouctou entre les membres du groupe et les femmes locales. mais il a plutôt affirmé que les mariages forcés ont toujours existé, ainsi que la discrimination à l'égard des femmes, sous plusieurs formes, comme par exemple la polygamie et la circoncision. Son témoignage sous serment est la preuve la plus fiable et ce sur quoi cette Chambre devrait se baser. Dans tous les cas, la fiabilité de cet article est particulièrement affectée par l'incapacité avouée du témoin de faire la différence entre les différents groupes, soit entre le Mujao et Ansardine. Le procureur fait également référence à un rapport de l'ONU publié en novembre 2012, qui rapporte des allégations générales aux groupes qui procédaient à des mariages forcés à Tombouctou. Ce rapport ne peut permettre d'attribuer une intention aux membres d'Ansardine. Encore une fois, rien ne prouve que M. Hassan ait lu ce rapport. Tout au long du procès, Monsieur le Président, Mesdames les juges, nous avons entendu de la preuve à l'effet que plusieurs femmes mariées durant les événements pouvaient demeurer à la maison avec leur famille et pouvaient recevoir la visite d'amis. Et la défense se réfère à son mémoire final au paragraphe 56. De plus, les femmes pouvaient refuser le mariage et il n'y avait pas de conséquences, tel que démontré au paragraphe 54 du mémoire final de la défense. Le simple fait que des membres du groupe se sont mariés à des femmes locales n'est pas suffisant en soi pour conclure à la commission de mariage forcé dans un dessein commun. Et en ce qui concerne la preuve spécifique des incidents faisant l'objet des charges, la défense se réfère à son mémoire final au paragraphe 216 à 254, dans lequel le manque de fiabilité et de crédibilité de chaque témoin a été remis en cause de manière étayée. Nous vous soumettons donc que le procureur n'a pas démontré que les 10 crimes ont eu lieu et faisaient partie d'un dessein commun. Le procureur vous demande de tirer une inférence de preuve circonstancielle qui n'est pas raisonnable et qui n'est pas appuyée par la preuve. Deuxièmement, passons à la conduite spécifique et à la contribution alléguée de M. Hassan au dessein commun. D'abord, la défense vous soumet qu'aucune preuve n'a été présentée à l'effet que M. Hassan avait la connaissance que les patrouilles de police ont servi à la commission de mariage forcé, ni n'a contribué en raison de son rôle administratif dans la police à organiser ces patrouilles dans le but de faciliter la commission de crimes. Le procureur donne comme exemple les cas de P520, P538 et P610. Prenant même pour acquis que les incidents se sont déroulés de la manière que les témoins l'ont allégué. Il est éloquent qu'aucune d'entre elles n'ont fait le lien entre les patrouilles et l'organisation de leur mariage. Ni aucune n'a reconnu M. Hassan. Il ne s'agit donc pas d'une inférence raisonnable que l'on peut tirer de la preuve présentée par le procureur, mais uniquement de spéculation. L'accusation reproche également à M. Hassan de ne pas avoir pris de mesures afin d'imposer des restrictions au comportement des membres de Ansardine lors des patrouilles. Encore une fois, pour ce faire, il aurait fallu tout d'abord que M. Hassan soit au courant de cette pratique. Ce que M. Hassan savait, par contre, c'est que les membres d'Ansardine avaient bien été informés de la prohibition de viol et que les membres du groupe qui n'étaient pas originaires de Tombouctou s'étaient vus expliquer les pratiques locales, telles que démontrées au paragraphe 55 du mémoire de la défense. Tel qu'indiqué par la Chambre préliminaire dans cette affaire, dans la décision de confirmation des charges au paragraphe 948, la contribution, en vertu de l'article 25.3d, doit être de nature à influer sur la commission du crime. En d'autres termes, elle doit produire un effet de causalité sur la commission des crimes. La simple référence au rôle de M. Hassan dans la police islamique ne peut servir à établir sa contribution, puisqu'il n'existe pas de lien entre la conduite de M. Hassan dans l'organisation des patrouilles et la commission des crimes. Le procureur ne fait aucune mention dans son mémoire final que M. Alassane aurait adopté des comportements faisant en sorte que les patrouilles étaient organisées dans le but de trouver des femmes aux membres du groupe. Le procureur n'a pas non plus démontré que M. Alassane était responsable de la formation et de la discipline à l'intérieur de la police et qu'il a manqué à son devoir. Maintenant, en ce qui concerne l'organisation du paiement des dots, la défense vous soumet que la seule conclusion possible est que M. Alassane n'a pas contribué ou participé à un quelconque dessein commun en fournissant son aide à un membre du groupe pour obtenir le paiement d'une dot pour se marier à une femme locale. Selon le procureur, dans son mémoire final, M. Alassane aurait rédigé une requête pour un certain Mohamed pour l'obtention d'une aide financière pour payer la dot. Au soutien de cette allégation, le procureur se repose exclusivement sur la déclaration de M. Alassane, obtenue, telle que discutée hier, alors qu'il subissait de la torture. Et plus spécifiquement, cette déclaration a été faite en date du 6 octobre 2017, le jour même où M. Alassane a demandé aux enquêteurs du bureau du procureur s'ils pouvaient l'aider à être transféré dans une prison régulière pour échapper à la torture qu'il subissait à la sécurité d'État. Sur la base de cette simple affirmation de l'accusé, obtenue alors qu'il était torturé, doit-on assumer que ce mariage a eu lieu? Est-ce que l'on peut spéculer à l'effet qu'il a résulté en un mariage forcé? Le nom de Mohamed est l'un des plus communs, les plus courants à Tombouctou. On ne connaît pas l'identité de la femme, la date ou le lieu de la conclusion du mariage, si la femme ou les parents de l'épouse ont été consultés au sujet de ce mariage et s'il y a eu consentement. Sans ces éléments, Monsieur le Président, Mesdames les juges, comment peut-on arriver à la conclusion que M. Alassane a signé une requête pour demander l'assistance de l'émir pour un mariage forcé? Est-ce que le simple fait d'avoir rédigé une demande pour un membre du groupe pour solliciter une assistance financière pour payer la dot constitue une contribution de nature à influer sur la commission d'un crime? Et même si on pouvait faire la preuve que M. Alassane a bien signé ce document pour ce Mohamed, est-ce qu'on peut conclure qu'il y a eu un lien de causalité? La défense vous soumet que non. Et encore une fois, le procureur vous demande de spéculer, parce que la preuve ne soutient pas l'inférence qu'il vous demande de faire. À la lumière de ce qui précède, la seule inférence logique qui peut être tirée est le fait que M. Alassane a possiblement contribué, a possiblement aidé à la conclusion d'un mariage selon les coutumes locales. De plus, il n'y a pas de preuve à l'effet que M. Alassane a exercé une pression quelconque sur des femmes pour qu'elles se marient à travers ses fonctions administratives dans la police. P150 a d'ailleurs admis ne pas avoir de souvenir que M. Alassane agissait comme intermédiaire dans un mariage. Même que P626 a affirmé qu'il était normal, même avant 2012, d'avoir recours à des intermédiaires qui jouissaient d'une notoriété à Tombouctou, comme c'était son cas, pour arranger les mariages. Enfin, le simple fait que M. Alassane savait que des membres de la police haut gradés s'étaient mariés à des femmes locales, soit Adama et Aboudar, ne confirme pas le fait que M. Alassane connaissait l'intention du groupe de mettre de la pression sur les femmes ou qu'elles n'ont pas pu refuser ce mariage. La défense a même présenté de la preuve à l'effet que le mariage d'Adama était consentant. Je vous réfère au paragraphe 20 de la réponse au mémoire final de l'accusation. Maintenant, en ce qui concerne l'allégation à l'effet que M. Alassane a joué un rôle de médiateur pour résoudre des conflits conjugaux, la défense vous soumet que le procureur n'a aucunement fait la preuve qu'il a joué un tel rôle en relation avec des incidents qui fait l'objet des charges ou qu'il avait la connaissance qu'il assistait dans la médiation de mariage qui était le résultat d'un mariage non consentant. Encore une fois, P626 confirmera aussi jouer un rôle de médiateur dans le cadre de conflits conjugaux avant et durant 2012 et qu'il s'agissait d'une pratique normale. Comment M. Hassan aurait donc pu savoir qu'il contribuait à la commission d'un crime s'il était dans l'ordre des choses à Tombouctou de servir de médiateur entre les couples en difficulté maritale? Il est également significatif que les femmes se sont plaintes pour diverses raisons de subir un préjudice dans leur mariage et se sont vues accorder un divorce par le tribunal islamique. Les femmes avaient l'option de se divorcer. Et je vous réfère à la note en bas de page 964 du Mémoire de la Défense où on liste plusieurs jugements à cet effet. Le fait de jouer un rôle de médiateur dans le cadre de conflits conjugaux n'a donc rien à voir. Troisièmement, les membres d'Ansardine n'ont pas profité d'un environnement coercitif pour commettre des crimes de violence sexuelle. Contrairement à ce qu'allègue le procureur, le port d'armes par les membres du groupe était à des fins légitimes de légitime défense uniquement, et les membres étaient bien instruits à cet effet, tel qu'élaboré dans le Mémoire de la Défense au paragraphe 49. De surcroît, un témoin du procureur, P654, un notable de Tombouctou, a affirmé que, avec l'occupation, les hommes commençaient à donner à la femme le mérite et le respect, qu'on ne provoquait plus les femmes dans les rues et que l'imposition de la charia mettrait éventuellement fin au vol et au viol, et c'était un aspect positif de l'occupation. Je vous réfère au transcrit 133, page 35. Cette affirmation du témoin est pour le moins révélatrice. Comment le procureur peut affirmer qu'il existait un environnement coercitif si les femmes de Tombouctou étaient plus respectées, qu'il y avait moins de pression sur elles et qu'elles pouvaient obtenir des divorces? Enfin, en ce qui concerne la commission des viols de certaines femmes en détention, la défense vous soumet tout d'abord que le procureur n'a pas été en mesure de démontrer que ces viols faisaient partie d'un dessein commun. Aucune preuve n'a non plus été présentée à l'effet que M. Hassan était présent lorsque les femmes étaient en détention. Néanmoins, il a été démontré par la défense au paragraphe 134 de son mémoire final que la plupart des femmes qui ont été détenues l'ont été par Mohamed Moussa, alors que celui-ci se trouvait à la BMS. P500 et non pas pour dénoncer le fait qu'il y avait eu des viols à Tombouctou. Et je me remets aux soumissions de M. Teller d'hier. Le procureur demande donc à la Chambre de tirer la conclusion que les viols étaient commis en détention et que M. Hassan avait la connaissance suffisante, alors que la preuve est à l'effet que les gens qui étaient présents à l'époque n'étaient même pas n'étaient eux-mêmes pas au courant. Le simple fait que M. Hassan ait affirmé que la convention du convenable et l'interdiction du blâmable étaient le travail de tout le monde ne permet pas d'établir qu'il a adopté une conduite qui a produit un effet de causalité sur la commission des viols en détention. Le simple fait que des femmes étaient détenues ne signifie pas qu'elles aient été victimes de violences sexuelles. le procureur n'a pas présenté de preuves fiables et crédibles à l'effet que les gardes étaient connus comme étant abusifs et agissaient en toute impunité, et qu'il était irréaliste de croire qu'ils pouvaient garder des femmes sans leur faire subir des abus. La référence du procureur au jugement de première instance du TPY dans l'affaire Kshojka au paragraphe 327 est donc erronée. Le fait que M. Al-Hassan savait que des femmes étaient gardées uniquement par des hommes ne signifie rien. Une telle présomption légale, Monsieur le Président, Mesdames les juges, n'existe tout simplement pas. Il s'agit au contraire d'un fait que le procureur doit prouver, ce qu'il n'a pas fait. L'accusation vous soumet avant-hier qu'Anne Sardine a clairement exposé toutes les femmes et les jeunes filles détenues à un risque de viol intervenant dans le cours normal des événements. Un risque n'est pas un seuil suffisant pour rencontrer le critère accepté par cette Cour. Maître Thaler a déjà abordé le test qui est requis, qui est une quasi-certitude. Un risque n'est pas une quasi-certitude. Il n'y a donc pas de preuve hors de tout doute raisonnable à l'appui du fait que M. Al-Hassan avait contribué à la soi-disant commission des viols en détention ou aurait adopté un comportement qui a facilité la commission des viols, ou même qu'il connaissait l'intention du groupe de commettre ces viols. Je vous remercie. Je vais passer la parole à mon collègue, Maître Youssef.
Merci beaucoup, Maître, pour votre brillante présentation et surtout pour votre concision. Alors, la parole est à votre collègue. C'est Maître Youssef.
Thank you, Mr. President.
Allez-y, Maître Youssef.
Thank you. Mr. President, Your Honors, this part of our closing submissions concerns the Islamic police reports and the prosecution's claims regarding their link to the Islamic Tribunal judgments. It is our submission that Mr. Al-Hassan did not make a culpable contribution to the proceedings before the Islamic Tribunal. Our submissions in this section have 5 small parts: the status of the evidence on the specific issue, the methodology of the police reports, the limits of the police's competence, the Islamic Tribunal's methodology, and last I will discuss the voluntary nature of the population's interactions with the Islamic police. Overall, it is our submission that the reports of themselves demonstrate that Mr. Al-Hassan was a low-level clerk. His actions were pursuant to the Islamic Tribunal decisions, which, when properly put in context, were orders. Thus, he cannot be said to have individually committed crimes or made a culpable contribution to a criminal purpose, as alleged, or at all. The prosecution provided us with Islamic Tribunal judgments and Islamic police reports and claimed the judgments were based on the police reports. And for most of the charged incidents, there is no evidence from the parties mentioned in the Islamic Tribunal judgments or the police reports. Witnesses were called who may have had knowledge about those incidents, but their personal knowledge of the incidents was not established. They never witnessed the drafting process of the police reports. They were not present in Timbuktu throughout the entire period, so they could not have possibly known about every specific incident. It was therefore crucial to establish their personal knowledge. And instead of calling that evidence, Your Honors, the prosecution is asking the chamber to speculate. When those witnesses appeared before this chamber, all they were asked by the prosecution was to repeat the names and dates they could read on both the reports and the judgments. Repeating names and dates on 2 separate documents gives no weight to the documents. Anyone who could read Arabic could have done that. The prosecution in the closing arguments, for example, referred to an alleged tribunal judgment. This is item 98 and 99 on the prosecution's list. A handwritten text inside a notebook. Here's another good example where a prosecution witness could have had knowledge about this incident, or the author, or the circumstances surrounding the drafting of that note, or the link with Mr. Al-Hassan, if any. And that witness testified before the chamber and was shown the document in the middle of a batch of documents, but no questions were asked about this incident whatsoever. So once again, the chamber is asked to speculate. And the Islamic Tribunal didn't hide it when they relied on other investigations for its findings. Let's take the example of incident 42. Here is an incident where Mr. Al-Hassan had no role whatsoever. The locals complained about the persons in question, as confirmed by witnesses D514 and witness P984. They were arrested by the security battalion and then taken to Hezbollah. A prosecution witness confirmed that a member of Hezbollah always oversaw the application of a sentence, and confirmed that in this particular case, a member of Hezbollah is seen reading out the sentence prior to execution. Mr. Al-Hassan was not present during the execution of the sentence, and the tribunal even recognized in the judgment the role of Hezbollah and the emir of Hezbollah in conducting investigations on this case. Hezbollah, Your Honors, not the police. We also have examples where the Islamic Tribunal judgment contains information not in the police report, which again shows that the tribunal did not rely on the police reports, whomsoever instructed to draft them or drafted them. For example, incident 19. We have a report that is one line, a driver found with 2 jars, one containing water and one containing cotton, as well as a piece of paper containing a magic text. This is it. This is item 98 on our list, Your Honors. The tribunal judgment, on the other hand, contains information on the route the person in question does as a driver, a more specific description of the items found in his possession, where the items were found, and the mention of his grandfather's funeral. It's item 99. Similarly, in incident 20, the report is only 3 very brief lines. The judgment, on the contrary, refers to the specific items in the possession of the person in question. It refers to the individual being questioned by the Islamic Tribunal and confessing before them. And while the prosecution claimed that Mr. Al-Hassan wrote the police reports, they did not establish how he received that information, especially that Mr. Al-Hassan was not acting alone in the police, and he had superiors who gave him orders. These alleged incidents demonstrate that the tribunal considered every aspect of a case when seized of a matter. Their work was not complementary to the police. Their work was done from scratch, under oath, independently, without reliance on the police report, as if the police reports never existed. Furthermore, the judgments make no mention of a police report. The mere existence of a police report doesn't mean the judges even saw it. And any link we try to establish here would be an assumption. And in some cases, before the Islamic Tribunal, the chamber has heard there's no police report at all. And the only logical conclusion here is that the Islamic Tribunal was able to, and did indeed, conduct the proceedings without any role by the police whatsoever. And those examples can be found in items 100 to 112 on the defense's list. It is therefore crucial not to generalize or make assumptions or speculate on the role, if any, played by the police or Mr. Al-Hassan. This is the only safe approach to this case on the issues when considering contribution. Mr. Al-Hassan made no contribution at all. As foreshadowed, I go on to make submissions on the methodology of the reports. The police reports are nothing but a summary of information, an untested account of what may have been said, and it was left to the Islamic Tribunal to verify or completely disregard. Almost all of the reports are half a page, and some of them are one line, which suggests that the police conducted no investigations. They conducted no investigations themselves. And this does not establish beyond reasonable doubt the role played by Mr. Al-Hassan, if any, in the proceedings before the Islamic Tribunal. Mr. Al-Hassan could not and was not qualified to predict how the tribunal would issue its findings. The prosecution witness testified that the Islamic Tribunal followed an approach of, and I quote, avoiding punishment should there be any uncertainty, and mitigating punishment commensurately with the nature of the crime in question. This was within the competence of the Islamic Tribunal, not the police. And we can also draw inferences from the fact that Hezba's composition included judges in the Islamic Tribunal, whereas the police did not. So the existence of the police reports further demonstrates the police's lack of competence or authority. Otherwise, the referrals would not have existed and the police would have issued rulings itself. And this leads me to the third part of this section concerning the limited competence of the Islamic police. There was no discretion or leeway for Mr. Al-Hassan or any member of the police vis-à-vis the processing of complaints or the implementation of the tribunal's verdicts. When the report reads to the Islamic court, this was not a prosecutorial act of seizing a court. It was nothing more than an indication of lack of competence, an indication of the definitive end of the police's minimal role in the case. The police, Mr. Al-Hassan and his superiors, were all under the obligation to transmit complaints to the tribunal. It was similar to the role of the registry in transferring the parties' submissions to a chamber. And even with that analogy, the police were not always approached, and parties went directly to the tribunal or through Hezba. The police was also under the obligation to transport individuals to the Islamic Tribunal, just like Mr. Al-Hassan was transported to the courtroom today. A transport service is not a contribution to the legal proceedings before a tribunal. Qutaiba, a key scholar in 2012, confirmed that the police or Hezba would be committing a forbidden act if they interfered with complaints for adultery, theft, or drinking alcohol. It was a forbidden act because the Qadi was the religious authority entrusted with the interpretation of the law and the issuing of sentences. Not the police, and certainly not Mr. Al-Hassan. We have heard witness D202 testify that questioning Sharia is questioning God or his representatives on earth. And as prosecution witness P65 testified, Mr. Al-Hassan was powerless to depart from the system. He was under the obligation to seek the decision of his emir and could not bypass him. And this puts superior orders into context, upon which Dr. Gary will speak later. We have also heard a prosecution witness testify that the Maliki legal school, also called in Arabic al-Madhhab al-Maliki, to which the locals were most accustomed, was followed by Ansar ad-Din and the Islamic Tribunal. It is an eminent and well-established authority in Islamic governance that is not inconsistent with international law. This legal school is not only followed in Timbuktu, but almost all of North and West African states, and can be found in countries in the Arabian Peninsula. This system of governance does not permit the police to make interpretations of the law or decide on disputes between parties or issue sentences. And even in a system of Islamic governance, the police still functioned like a regular police and civilian registry. In this system, Hezba, not the police, apply and enforce religious rules. And as confirmed by Qutaiba, the emir of the police could not issue decisions on ta'zir. Given that Ansar ad-Din was following a standard and widely accepted system of Islamic governance, Mr. Al-Hassan could not have possibly known that his participation would, in and of itself, be contrary to international law. In the prosecution closing arguments, we were shown a video where Mr. Al-Hassan is portrayed to have said he should defend Islamic law until he dies. This is not an extremist pact or a hostile statement. This is an expression of belief, a belief that made it impossible for Mr. Al-Hassan to disobey religious orders or take the risk of departing from his faith. We have, for example, heard witness D272 testify that while he might not be personally in favor of applying some of the Sharia rules, he was simply incapable of contradicting them. Witness D213 also said that as a Muslim, he could not be opposed to Sharia. D240 said that Sharia was recognized in Timbuktu and by the majority of Muslims. Prosecution witness P654 explained how, before 2012, each community in Timbuktu had a Qadi, referred matters to customary chiefs, local imams, and Timbuktu, and I quote, Timbuktu has always functioned like this. Imam Dawood, a local notable who was also a member of the Islamic Tribunal at the time, said, and the quote is in French, Nulle justice n'est meilleure et préférable à celle de la loi divine. Fin de citation. This position does not turn these individuals into extremists. This is a belief shared by many other individuals from the Muslim faith, including Mr. Al-Hassan. This is the belief and obligation that Mr. Al-Hassan complied with, and that should not be punished with an extremist label. I now moved on to part 4 of this section, Your Honors, and it concerns the Islamic Tribunal's methodology. A prosecution witness testified that the Islamic Tribunal had to leave no stone unturned to ascertain the truth. He and other witnesses said that the Islamic Tribunal conducted its own investigations from scratch. We have examples of the Islamic Tribunal's hearings. The tribunal notes thoroughly demonstrate how the judges heard the witnesses and took note of their accounts. And again, their notes contain no indication of a role played by the police in the investigations whatsoever. This is item 124 on the defense list. The prosecution's claim that the tribunal judgment was based on the police reports is baseless. Besides matching names and dates, no progress in this trial was made to provide the necessary link between the alleged reports and the Islamic Tribunal findings. And today we are right where we started, with no proof of the prosecution allegations at all. So we are left with what we see. And what we see at most is that none of the Islamic Tribunal judgments even mention the existence of the Islamic police reports. None of the Islamic Tribunal judgments acknowledge any role played by the police in the findings issued by the tribunal. We have also heard before this chamber a prosecution witness who testified that Mr. Al-Hassan did not have any influence over the court and did not contribute in any way to the decisions reached by the court. He also testified that Mr. Al-Hassan did not take part in any court duties. Incidents must therefore be assessed on a case-by-case basis, and no assumptions should be made on the role, if any, of Mr. Al-Hassan or the police in the proceedings before the Islamic Tribunal. Now I move to the last part of our submissions in this section concerning the voluntary aspect of approaching the police. The prosecution has called evidence of many cases of individuals who were seeking protection from thieves and bandits, women who were ill-treated by their husbands, people who were claiming debts, people who wanted to protect their commerce or land, others who wanted to retrieve property stolen by looters, and others who simply wanted to honor contractual obligations. D240 affirmed that no pressure or influence was applied when he appeared as a witness before the Islamic Tribunal. The population continued to approach the police voluntarily and lodged complaints all throughout 2012, simply because it was useful to them and because their rights were preserved. And this is what Mr. Al-Hassan would have seen. This is what Mr. Al-Hassan would have understood. And not only did the population continue to approach the police with their concerns, but they were also supportive of the role it played in deterring theft. They continued to file complaints of theft after the amputation, until as late as September 2012 to early December 2012. And here I refer to incidents 24, 27, and 35. These were incidents filed by members of the Arab community against members of the Arab community, and we have heard evidence that the Arab community applied Sharia before 2012. Notables deplored theft in the greatest terms. Prosecution witness P4, speaking about a theft case of fuel used by the population, said, and I quote, the quote is in French, Nous avons honte de toutes ces pratiques faites par les Tombouctiens, nous qui sommes fiers de nos valeurs, nous si dignes, si fiers, quelle bassesse, quel crime le vol, quel déshonneur. Fin de citation. We have heard evidence about the locals calling the green number provided by the groups in the middle of the night asking for help, and they were provided with immediate assistance, as confirmed by witness D554. The Islamic police performed its tasks without discrimination based on ethnicity or tribe or social status, as confirmed by prosecution witnesses P65, P150, and defense witnesses D93, D315, D551, and D553. Your Honours, insofar as this evidence negates knowledge or assists on the affirmative defences, and this will be addressed shortly by Dr. Gary, but at this stage, we submit that the evidence is such that the prosecution simply cannot prove there were criminal acts nor a common purpose arising from the police reports. And it follows that there is no evidence, Your Honours, Mr. Al-Hassan was anything more than a low-level clerk, acting on orders in accordance with decisions made with basic judicial guarantees and in accordance with public acceptance and understanding. Thank you. With your leave, Your Honour, I will pass the microphone to Dr. Gary.
Just pass me the lectern.
Merci beaucoup, Maître Youssef, pour votre brillante et éloquente présentation. Et maintenant, la parole est à Maître Gary. Docteur Gary, vous avez la parole, s'il vous plaît.
Mr. President, Your Honours, I will speak very, very briefly on the important context of Islamic law and the affirmative defences, and close on behalf of the defence for Mr. Al-Hassan. I start with a summary of the situation and context in 2012. The great power of this International Criminal Court is its ability to make simultaneous inquiry into a situation and the potential criminal liability of an accused person within that situation. It is a power that is intended to have universal reach, with a vision of international law that includes the Muslim world. It is a power that must be exercised in context and with great responsibility. When this chamber sits down to make findings on the situation in Mali in 2012, we submit it must be recalled that Timbuktu is and always was traditionally, culturally, a major hub of Islamic civilization. For centuries, Timbuktu has thrived as a centre of Islamic culture and learning. It is appropriate, we submit, to conclude on the evidence in this case that Islam is indeed the soul of Mali. In 2012, Mali was also a post-colonial society, and as Ms Pradhan has explained before me, it is commonly understood that post-colonial or neo-colonial instability is not the same as an armed conflict. Instability is a feature of history. It is a feature of Mali history. It is our submission that central to this case is the need to understand Mali and to understand Islam and the Muslim society in Mali, which 90% of the population adhere to. The evidence explains that the term Islamic law covers the entire system of law and jurisprudence associated with the religion of Islam. In many ways, like any jurisprudence, it can be divided into two parts, namely the primary sources of law, Sharia, and the secondary sources of law with the methodology used to deduce and apply the law, Islamic jurisprudence or fiqh. These are considered by Muslims to be of divine revelation and thus create the immutable part of Islamic law. You can conclude on the evidence that in Mali, Islamic or Sharia law is and always has been the heart of the population's cultural, legal and political society. You have heard evidence that there are various schools of thought. The evidence is such that you may infer a lack of consensus as between schools. The prosecution did not call independent expert evidence, but you have clear evidence that there are differences in interpretation of the Quran by scholars and judges. However, that does not make the work of Ansar Deen nor the Islamic Tribunal extreme. Interpretation is fundamental in law and is fundamental in Islamic law. It is the element that separates the madhahib, the ways to act, from one another. It is the way. While there is no question that the Quran is the first source of Sharia, there is no evidence to enable you to choose differences among the schools, nor to rank other sources of Islamic law, nor should you do so. The sole evidence is that the Maliki school of thought may have been followed. At best, this is evidence of an attempt at stability and legal certainty. It is not evidence of an extreme ideology. This is not a case where mock trials of the population were held. It is a case where governance and law was legitimate. It is not for this chamber to impose a selective approach to Islam on Mali in 2012. Ansar Deen was not bringing new rules, as alleged or at all, but protecting the traditions, population and heritage of the city and the region, and, for example, appointing scholars and having structures which ensured that the decisions made were valid in Islamic law and would be accepted as valid by the population. The libraries still stand and the manuscripts are safe. Whilst crisis in name, any crisis in fact was averted through peaceful consultation with local dignitaries, an Islamic tradition reflecting the usual Islamic nature of Ansar Deen. The evidence is that Ansar Deen governed according to customary Islamic law and established practice, and the police were subordinate, not part of any governance structure or policy making. We know this from the evidence of Abu Zaid's instructions that policy and procedures were decided by the Emir, and from the evidence of Qutaiba's interview, which clearly restricted the powers of the police to a secondary organ. Timbuktu has never been a Western cosmopolitan city. It was socially conservative and controlled by religious notables where traditional values were preferred. Before, during and after 2012, Qadis and sheikhs applied Sharia to resolve disputes in matters ranging from marriages, divorce, adultery, theft and murder with valid interpretation. No expert has suggested otherwise. The Malian authorities were aware these judges exercised this role. Ansar Deen continued this tradition, and those employed, like young Mr. Al-Hassan, worked in a customary Islamic situation and context. It therefore cannot be inferred from the Islamic processes and decisions made that any international crime would occur in the ordinary course of events, nor that any crime was virtually certain. To suggest there were no basic guarantees is tantamount to suggesting that Mali is to be held to a higher standard than most state parties in a transitional situation, particularly when people in an Islamic country needed the basic Islamic structures that they were afforded. As Ms Taylor has explained, Ansar Dine can and should be characterised as at most a national group. It did not amalgamate with AQIM. Ansar Dine restored services, brought security and access to justice according to customary Islamic law. Its member Hooker has since been commended and not prosecuted. This is good evidence that Mr Al-Hassan was never party to an unlawful conflict because there was no armed conflict. There was an attempt at stability and nothing more. A proper analysis month by month of the situation in Mali in 2012, as presented by Ms Taylor, is that there was no criminal purpose or policy. Turning to the accused person, the evidence shows that Mr Al-Hassan is and was a respectable member of the ancient Tuareg tribe. Mr Al-Hassan stayed in Timbuktu out of necessity. He was not zealous, but a Muslim doing his job properly. As Mr Yusuf has explained, in 2012, Mr Al-Hassan served his fellow people as a low-level subordinate to whom the governance of Timbuktu, through customary Islamic law and principles, was lawful, including the punishments according to Sharia. His were honest and genuine and reasonable beliefs. On Tuesday, the apparent zenith of the prosecution case this week was a video at their item 103 in which Mr Al-Hassan says that he believed Islam was being followed. No caliphate, nothing extreme, no AQIM propaganda, just Islam. Allegedly having keys to handcuffs, a walkie-talkie or a phone, as suggested by the prosecution on Tuesday this week, does not make a leader. Even the prosecution outline on Tuesday itself showed that Mr Al-Hassan's role was of an ordinary police officer. As Madame Beaulieu-Lucier has explained, marital relationships were without Mr Al-Hassan's knowledge or were consensual or appeared so, even if this chamber concludes that created a mistake. He did not commit rape, nor was he complicit in any sexual offence or persecution. On punishments, for example, the prosecution played a video of Mr Al-Hassan accompanying Musa to fulfil his sentence. It must be remembered that this sentence of Musa was for murder, where the accused man had shot a farmer, where Musa's defence of self-defence was rejected in properly held proceedings demonstrating basic trial rights were indeed afforded. It misleads this chamber to suggest that Mr Al-Hassan was anything other than being supportive. The actual evidence was that he talked to the family about Dia, but they asked for Kisas. So at most, Musa had Mr Al-Hassan's company as the sentence proceeded. This chamber can properly conclude that Mr Al-Hassan's role was one of service, not of criminal conduct or purpose, and not of persecution. He plainly had no purpose to subjugate or denigrate anyone. He worked as an ordinary police officer, a civil functionary doing his best for his family and the population according to ordinary Islamic structures. All of this is clear from the evidence. Superficially, the core issue is simple. Criminal liability only flows where a person is aware that a circumstance exists or a consequence will occur in the ordinary course of events. In this case, knowledge is more complex because of the way that the prosecution put their case. They must prove knowledge of the situation as they suggest it was, knowledge of the alleged purpose, if such a purpose can be proved at all, as well as knowledge of the alleged individual crimes within Mali. This inevitably contains some objective factors, as the Chamber must make findings on the ordinary course of events in Mali, where Islamic law was customary and governance and judgments in 2012 were through Islamic law. It is our submission, taking this approach, there is no safe foundation to convict Mr. Al-Hassan. It is also not a mere knowledge test. That would remove the operation of intention. We say the proper approach can be expressed as follows. He did not know the essential facts about the alleged crimes or the alleged purpose, and his liability is excused because he was, or may have been, which allows for reasonable doubt, operating under a mistake in circumstances of necessity and bound to follow superior orders. It is in this way that the defences of mistake of fact or law, superior orders and duress are applicable to all the confirmed charges, because they are all relevant to his alleged knowledge, intention and conduct. For example, not only did he not participate in the subjugation of women, he did not know the use of Islamic law was unlawful, because in Mali in 2012, it wasn't. The prosecution conceded in their closing address on Tuesday that the religion was Islam, and the request by Ayad Ag Ghali was simply to abide by the Quran. We submit that it is impossible for this court to infer, for example, that regulating smoking and drinking, theft or clothing, as set out in the Quran, would mean that Mr. Al-Hassan knew international crimes were being or would be committed. Mr. Al-Hassan, a family man and police officer, was tasked with following Islamic governance and law and obliged to do so. It was lawful and he believed it was lawful, even if this chamber concludes he was mistaken. The suggestion in paragraph 574 of the prosecution final brief that the defence has responsibility to substantiate its claims that affirmative defences apply is misconceived. As set out in detail in our final brief and response, substantiation suggests a legal burden on the accused, whereas it is an evidential burden. Assuming what the prosecution meant was that there must be evidence of substance for the chamber to consider on the affirmative defences, we submit this has been achieved. On mistake, the fact that there were meetings with local dignitaries, that issues were listened to and adaptations were made was not meaningfully challenged. There was evidence that Ansardine restored services and gave free health care, which allows for an inference of what Mr. Al-Hassan saw in terms of legitimacy. Society was visibly Islamic. On duress, discrimination of the Tuareg was rife. This chamber must reject the legal representative of victims' submissions that being a Tuareg is equated with criminality. On superior orders, bearing in mind that this is both a defence and the context for any mistake, there is evidence that the supreme authority was held by the Islamic Tribunal and the absolute prerogative was Adam's, then Khaled's and Abu Dar's. The evidence demonstrates that Timbuktu is and was Islamic and Mr. Al-Hassan functioned within Islamic law and governance. Returning to the prosecution video at their item 103, we can see and hear Mr. Al-Hassan's honest and genuine and reasonable belief that Islamic law was being applied. Nothing extreme, nothing foreign. He literally says Islam. The logical conclusion is that there was no extreme vision, and if there was any mistake, it was honest and reasonable, and any conduct was unavoidable. Put another way, there is ample evidence that a reasonable person in Mr. Al-Hassan's position would believe that people were governed and judged according to Islamic law, even if using an interpretation, and that Islamic punishments were carried out following a proper order. Accordingly, even if this chamber thinks that Mr. Al-Hassan was operating under a mistake of fact or law, he is excused. The fact that the public engaged extensively in that system suggests this was a belief held by many, making it reasonable for Mr. Al-Hassan to believe as he did. P150, a witness, said that Sharia was to be followed. On this alone, Mr. Al-Hassan can reasonably claim he acted lawfully. Intention cannot be inferred from circumstances of legitimacy, mistake, or necessity. He also played no role in the decision to apply Sharia or subsequent decisions concerning how it should be interpreted and applied. Ansardine's work was directed towards ensuring protection, harmony, and positive outcomes for the local population as a whole, which, to Mr. Al-Hassan, was a lawful result. Notably, local imams also counselled the local population to obey and cooperate with the groups. Given this backdrop, it was not unreasonable for Mr. Al-Hassan to act as he did with a positive impact for the local population. Refusal would have placed Mr. Al-Hassan and his family in grave danger. His alleged presence at punishments was mandated. He was never empowered with the responsibility or power to decide punishments. The sole area of discretion afforded to him was mediation and reconciliation, which he did. As I have said, it is too great a stretch to decide that international crimes can be constructed from interpretive Islamic law and governance, and reasonable doubt as to knowledge is sufficient to acquit. There is sufficient evidence for this chamber to conclude that governance and judicial decision-making were lawful and therefore lawful to Mr. Al-Hassan, particularly as a Muslim Tuareg, subject to orders, even if this chamber concludes he was mistaken. The suggestion that Mr. Al-Hassan could have fled is fanciful. The prosecution simply cannot rebut the reality in that context. Mr. Al-Hassan's actions were a reasonable and necessary response, allowing him to protect himself, the local population, and his family. So, in conclusion, on behalf of the defence, in a criminal trial, we submit that however confronting some evidence may be, the consequences cannot be laid at the door of Mr. Al-Hassan. This chamber must maintain standards of both law and evidential process and develop the law on knowledge and affirmative defences to function safely on the factors we have identified. The prosecution written and oral submissions were strikingly absent of law, leaving you to grapple with the legal principles we have outlined. The evidence we have of Mr. Al-Hassan's knowledge is that he was working where Sharia was applied. He believed this would bring justice for the community, and he worked for the community. The prosecution case, and I have about 12 words left, if I may, the prosecution case suffers from...
Yes, please, you may.
The prosecution case suffers from misreporting, flawed evidence gathering, reliance on torture-tainted interrogations, and myopia on Islamic law, such that there is reasonable doubt on every charge when Mali is properly understood and the international criminal law in the Rome Statute is properly applied. The correct outcome for Mr. Al-Hassan is to conclude his conduct was not unlawful nor intended to be, and to acquit of all charges. The two words you must find are not guilty. Thank you.
Merci beaucoup, Dr Jerry, pour votre brillante et éloquente présentation. Maître Taylor, quelle est la situation? C'est bien la fin de votre plaidoirie?
Yes, thank you very much. That concludes our presentations.
Merci beaucoup, Maître Taylor, pour la fin de votre plaidoirie, pour la fin des présentations, des brillantes présentations par vous-même et par vos collègues, vos consoeurs et confrères. À présent, nous allons passer aux questions de la Chambre. Madame la juge Akane va poser la première question et nous allons la suivre. Madame la juge.
Thank you, Presiding Judge. The prosecution described P0580's daughter in paragraph 261, 264, and 318 of its final brief. The defense described P0580's daughter and made references to a name that was previously communicated to the parties by email in paragraphs 333, 460, 464, and 467 of its final brief. My first question is, do all these descriptions of P0580's daughter or to the name previously communicated to the parties by email refer to the same person as P0580's 7-year-old daughter, reference to paragraph 287 of the confirmation decision? This is the first question. And secondly, the prosecution refers to P0580's eldest daughter in its trial brief at paragraph 142. The prosecution makes no mention of this eldest daughter of in its closing brief, but rather refers only to P0580's 7-year-old daughter. Does this mean that the relevant parts of the confirmation decision that have been communicated to the parties by email refer to P0580's 7-year-old daughter? I'd like to give the floor to the prosecution first. If you need to go into private session, please do so with the presiding judge's relief.
Monsieur le procureur, vous avez la parole. Si vous pensez que nous devons aller à huis clos partiel, vous pouvez le dire.
D'abord, je remercie la Chambre de cette question, puisque ça permet de clarifier quelque chose qui était sans doute pas très clair dans nos conclusions. Et je remercie la Chambre de cette opportunité de clarifier ce point. Une partie de la réponse peut être en audience publique, une autre peut être à huis clos. Ça permettra de maximiser la publicité de l'audience, même si ça nécessite un peu de manipulation de la part du greffe, et je m'en excuse d'avance, mais effectivement la sécurité prime. Je vais commencer en audience publique, très rapidement passer à huis clos et finir en audience publique, si c'est la Chambre agrée à cette démarche.
Tout à fait. Allez-y, monsieur le procureur.
Alors, effectivement, Monsieur le Président, Mesdames les juges, en ce qui concerne le premier volet de la question, la fille de P0580 mentionnée dans le mémoire final du procureur correspond bien à la fille de 7 ans de P580 mentionnée dans la décision de la Chambre préliminaire 1. Relative à la confirmation des charges. Et son incident est inclus dans les chefs 1, 2, 3, 4, 5 et 6. Je demande maintenant votre indulgence et à passer en audience à huis clos si vous le voulez bien, Monsieur le Président, Mesdames les juges.
Tout à fait. Madame la greffière, huis clos partiel, s'il vous plaît.
We're back in open session, Mr. President.
Merci beaucoup. Monsieur le procureur, vous avez la parole.
Merci, Monsieur le Président. En ce qui concerne le deuxième volet de la question, la position du bureau du procureur est que la fille de P580 mentionnée dans la décision de confirmation des charges correspond à la fille de 7 ans et non à la fille aînée. Et certes, effectivement, l'accusation a fait référence à la fille aînée de P580 dans son trial brief, parce que lors de son entretien avec l'accusation, la témoin P642 a raconté comment leur fille aînée avait été détenue et fouettée. Mais les violences subies par la fille aînée ne sont pas incluses dans les charges. Et la référence à la fille aînée, Mesdames les juges, Monsieur le Président, visait uniquement à illustrer l'ampleur de la violence et du harcèlement infligé à divers membres de la famille de P580 et P642. Voilà ce qui conclut notre réponse à la première question et à ces deux volets. J'espère avoir éclairé la Chambre sur ce point.
Thank you, Mr. Prosecutor. I will now turn to the legal representative of the victims. Would you like to make some observations in relation to this question, if any? Mr. Sita?
Merci, Madame le juge, de nous passer la question. Les représentants légaux n'ont pas d'observation particulière à faire à cette question. Je vous remercie.
Thank you very much. Now, I'd like to give the floor to the defense. Mr. Taylor?
If I may just set myself up a little bit. It's quite a lot of wires. Thank you very much, Mr. President, Your Honours. I believe I can answer in open session if I refer to the youngest daughter as the first daughter and the eldest daughter as the second daughter, if that would be convenient for the chamber. And I won't refer to the specific age, but I will refer to the young age of the first daughter on the understanding that the chamber is aware of that age.
That's fine.
Mr. President, Your Honours, it is a submission of the defence that the name of the first daughter, as mentioned in our closing brief, is the same and is in fact the first daughter, the youngest, but it is also our position that the facts are fundamentally different, such that the incidents addressed in our brief and in the evidence do not correspond to the facts confirmed by the chamber concerning the youngest daughter. I will first go through the facts as confirmed by the chamber and then the developments afterwards. And as the prosecutor has addressed you today, at the time of the confirmation decision, the pretrial chamber only had the statement of 580, and the chamber's decision was framed on the basis of his evidence. And in that decision, at paragraph 301, they made the following findings concerning that daughter. First, that she was very young. Second, that she visited P580 when he was detained by Hamid Musa and then locked up the place where women were detained. And it was after she was taken to the police and thrown into the prison for women that she was assaulted twice. She was then taken to a hospital and whipped 20 times. So they're the confirmed facts concerning this youngest daughter. And when the chamber confirmed these incidents, they placed particular emphasis on her young age and the fact that the physical violence had taken place while she was detained. So that was a key component of the confirmed incident concerning her. And when this trial chamber issued the self-contained set of charges, they described the incidents as follows: acts of violence and other forms of ill treatment committed against P580's daughter, who was arrested in Timbuktu, detained and sentenced by the Hezbollah to whipping, which sentence was carried out in certain time periods. So again, this indicates that the gravamen of the incident pertained to her detention and sentencing by Hezbollah. It's our position that the chamber can't replace the names of the two daughters, but they also can't use the new facts for the youngest daughter. And first, that's because there's been no notice of such a fundamental change in the charges, and it would exceed the chamber's competence to mould the charged facts to fit the evidence. And second, P642's testimony doesn't prove the confirmed charges, irrespective of whether you base it on the youngest or the eldest daughter. Now, in terms of the issue of notice, Article 74 prescribes that the chamber can only be based on facts and circumstances confirmed by the pretrial chamber. And the appeals chamber judgment issued on 1st of July 2021 in this case, and that's the filing 1562, paragraph 1, confirmed that Article 74.2 binds the trial chamber to the facts and circumstances described in the charge. And they use that word binds deliberately. And we have a host of case law from the appeals chamber confirming that there's a fundamental distinction between changing the legal characterization of the facts and circumstances of the charges and confirming or changing the facts themselves. And for the latter, resort has to be had to Article 61.9. And I refer to the appeals chamber's judgment in Labunga 2205, that's the number, paragraph 94. In that same judgment, the appeals chamber cautioned in particular that to give the trial chamber the power to introduce new facts would usurp the power of the prosecutor and would violate the proper distribution of powers within the statute. Effectively, the chamber would become a prosecutor, and that was at paragraph 94. Now, I am aware that in the judgment issued in this case, the 1st of July judgment, the appeals chamber did say in case of ambiguity, the chamber could look at the DCC, that is the document containing the charges, to see if there's an ambiguity. But here there was no ambiguity in the decision confirming the charges, and these additional new facts concerning the first daughter were never in the prosecution's own charges. So you can't extrapolate from the charges because these new facts simply weren't there. Similarly, the fact that the new facts are similar to other facts or that they fall within the charged time period or location is neither relevant nor sufficient. As stated by the appeals chamber in Labunga, the fact that new facts have come to light during the trial and build a unity from the procedural point of view with the course of events described in the charges does not cure a breach of Article 74, subsection 2 of the statute. And that's paragraph 92 of the judgment with the number of 2205. Now, these principles have to be interpreted in a way that's consistent with our right to timely notice. The prosecution could have amended the charges after they interviewed P642, after they received slightly different facts concerning her, but they chose not to do so. They wanted to have their cake and eat it too. They wanted to rely on the more serious allegations from P580, but at the end, they dropped P580 with no notice to the defence and no ability for us to recalibrate our investigation or case. Even then, they made no application or no notice that they were going to rely on new facts rather than the confirmed incidents. Now, in terms of my second aspect, that P642's evidence doesn't relate to the confirmed charges, this applies irrespective of whether you assume it's the first daughter or the second daughter. If we assume it's the youngest daughter, the charges were predicated on the fact that she was punished for not wearing a veil. and that she suffered the mistreatment at the BMS itself and was flogged. But P642's evidence does not confirm or relate to any of those charged incidents. At transcript 156, page 14, line 1, when asked what happened to her daughter, she said, "I couldn't tell you." So we have none of those confirmed details that were fundamental components of the charged incidents. She also provided absolutely no evidence concerning the eldest daughter. None. The prosecutor didn't even pose a single question to her on that point. There's therefore absolutely no basis for this chamber to issue findings on either the first daughter, given that the evidence does not correspond to the confirmed charges and constitutes entirely new incidents which were never confirmed, nor is there any basis for the chamber to enter a conviction in relation to the second daughter, given that we had no evidence come out at trial, and the prosecution itself today has confirmed that they're not bringing charges in relation to the eldest daughter. Thank you very much.
Thank you very much. I'll back to President. Thank you.
Je remercie Madame la juge Akane pour sa question et naturellement je remercie les parties et les participants pour leurs interventions. À présent, je passe la parole à Madame la juge Prost pour notre deuxième question. Madame la juge.
Thank you, President. I have a similar question for clarification, and it has been framed in a way that it can be presented in public session, but should either any of the party participants need to go to private session for a response, please seek leave from the presiding judge. The confirmation decision in paragraphs 610 and 611 referred to the place where P538 was detained on several occasions. The Chamber also notes that in paragraph 261 of the prosecution trial brief, the prosecution placed the location of P538's alleged rape by multiple men at this same place. In its final brief, the prosecution stated that P538 was temporarily detained in a place, and that's in quotations, which the witness described and called by a particular name, and raped by multiple different men. I'd just like to clarify what the prosecution's position is as to the place where P538 was detained during her alleged final detention. And if you can please specify the evidence supporting that position. Thank you.
Monsieur le procureur, vous avez la parole, s'il vous plaît.
Je vous remercie, Madame la juge. Merci, Monsieur le Président. Et je vais pouvoir répondre en public sans aller à huis clos, y compris en mentionnant le lieu que Madame la juge a eu la précaution de ne pas mentionner, mais qui, à mon sens, peut être dit publiquement sous le contrôle de la Chambre. Alors, en ce qui concerne cette deuxième question, Monsieur le Président, Mesdames les juges, concernant P538, la position de l'accusation est que le dernier endroit où P538 a été détenu correspond à l'hôtel La Maison, qui a servi de siège au tribunal islamique, qui appliquait des règles et sanctions qui n'existaient aucunement dans cet État laïque et où seul le droit pénal découlant de la loi malienne s'appliquait. Au cours de son témoignage, P538 a témoigné qu'elle était enfermée à Cha-Cha-Cha et que c'était là où il rendait justice. Et elle a aussi clarifié que Cha-Cha-Cha était un quartier qui se trouve à côté du quartier Abaradjou. Alors, un premier point, c'est qu'il n'y a pas que P538 qui a parlé du lieu de Cha-Cha-Cha. Deux témoins, P557 et P520, ont aussi fait référence à un quartier appelé Cha-Cha-Cha ou Che-Che-Cha. Tout d'abord, P557 a témoigné qu'il a été amené à un hôtel dans un quartier qu'on appelle Che-Che-Cha. Et il a expliqué que c'est là qu'il juge les gens. Donc en termes de pure localisation, cela corrobore les dires de P538 qui dit qu'elle a été enfermée à Cha-Cha-Cha et que c'était là où il rendait justice. Donc sur la localisation, c'est compatible. Pour sa part, P520 a également mentionné un quartier appelé Che-Che-Cha, qui était situé, à ses dires, dans les alentours du marché Yobutao. Et P520 a ajouté Abaraju et Che-Che-Cha, c'est la même chose. Vous l'avez au transcript 149, page 36, ligne 20, jusqu'à la page 37, ligne 9. J'ai les autres références pour P557, mais je ne voulais pas interrompre trop longtemps la réponse. Et donc, si on met en parallèle P520 et P538, selon lequel Cha-Cha-Cha était un quartier qui se trouve à côté d'Abaraju, c'est là aussi compatible. Et je rappelle que l'hôtel La Maison est bien situé dans le quartier Abaraju, et vous avez les cartes en annexe à notre mémoire écrit finale qui vous permettent de le localiser. Autrement dit, les dires de 557, 520 et 538 sur le lieu de Cha-Cha-Cha et la location du tribunal, l'hôtel La Maison, sont cohérents. Et ils sont aussi conformes à la réalité sur le terrain. Comme je l'ai dit, les cartes, mais aussi vous pouvez les voir dans le rapport des deux experts P55 et P57, MLI-OTP 0060 1920, page 1932. J'en viens à un deuxième point, c'est que la description du bâtiment à Cha-Cha-Cha telle que faite par P538 est corroborée par les éléments de preuve. P538 a témoigné qu'il y avait plusieurs chambres dans le bâtiment à Cha-Cha-Cha et elle a indiqué que la pièce où elle a été détenue était au rez-de-chaussée. Et elle indique que c'était à l'étage, je cite, qu'on fait les jugements. Et comme détaillé dans les rapports des experts 55 et 57, il y a effectivement plusieurs chambres au rez-de-chaussée de l'hôtel La Maison. Il y a des photos, des dessins, des plans. Et plusieurs témoins, y compris par exemple P626, D0202 et P150 ont effectivement mentionné que le tribunal se réunissait à l'étage supérieur. Vous le voyez dans des vidéos ainsi que dans la plateforme interactive qui a été déposée en preuve. Alors à ce stade, je dois dire que la défense conteste les récits de P538 concernant sa dernière détention en se référant au témoignage de D0202, selon laquelle personne ne restait la nuit dans le bâtiment du tribunal. Mais D202 admet lui-même qu'il n'y passait jamais la nuit. Il n'est donc pas en mesure de savoir ce qui se passait à cet endroit pendant la nuit quand il n'y était pas. Au total, la preuve au dossier indique que le bâtiment de Cha-Cha-Cha décrit par P538 pendant son témoignage correspond bien à l'hôtel La Maison. Alors, certes, dans le trial brief, l'accusation se réfère à la déclaration écrite de P538. C'est alors la preuve disponible. Au présent stade, l'accusation se réfère naturellement sur la déclaration sous serment faite en salle d'audience devant votre chambre. Et je dois souligner que la preuve ne démontre aucune mauvaise foi de la part de P538. Son témoignage sur la localisation du dernier lieu de détention et sa configuration interne correspond à la preuve. Plus généralement, son témoignage concernant son mariage forcé avec un membre d'Ansardine et d'ACMI est cohérent et corroboré notamment par des preuves documentaires. J'évite de les mentionner parce qu'on peut rentrer dans quelque chose d'identifiant, mais c'est au dossier de la preuve et nos conclusions écrites. Et la défense a eu la liberté et l'opportunité de contre-interroger P538 sur tous les points qui lui semblaient pertinents. En conclusion, la Chambre appréciera en toute souveraineté le témoignage de cette victime en tenant naturellement compte du fait qu'il s'agissait d'une personne analphabète et pour laquelle VWS a recommandé à l'époque des mesures spéciales prises pour son témoignage, y compris l'utilisation de questions courtes et simples et d'un langage facile à comprendre. Je vous remercie, Madame la juge, je vous remercie, Monsieur le Président, je vous remercie, Madame la juge.
Thank you very much, Mr. Duterte. I turn to the legal representatives of victims to see if there's any comment that you wish to make on this particular question.
Je vous remercie, Madame la juge. Les représentants légaux, pour cette deuxième question, n'ont pas non plus d'observation particulière à faire. Je vous remercie.
Thank you very much. I turn then to the defense. Ms. Taylor? You have the la parole.
Thank you very much, Mr. President, Your Honours. Your Honours, it's our submission that there are two possible judicial responses to this issue, and I'll go through each of them in turn. The first, it's clear that P538's testimony deviated in a material manner from the confirmed facts and circumstances. And we can see that the location of the detention is a material fact if you look at the charges. In particular, the prosecution pleaded in their document containing the charges expressly that she was imprisoned at the Gouvernerat, and that was paragraph 802 of the document of the charges. Then, at paragraph 813, they argued that the pretrial chamber had to put specific emphasis on the fact that she was detained at the Gouvernerat in order to find that her husband was in fact a member of Ansar Dine and not a member of the MNLA as stated in her statement. So it's clear that the location of her detention, as pleaded by the prosecutor, was a fundamental aspect of the confirmed charges. This change, this deviation in this material fact, was never notified to the defence timelessly through an amendment nor through disclosure. It only came out in her testimony. Even today, the prosecutor has confirmed that in their trial brief, they continue to state that she was detained at the Guvnera. And I've gone through the preparation log, which was the only information that we had, and even in the preparation log, when she reviewed her statements, she did not change the location of her detention. We can, however, see at page 20 that she was shown the video MLI OTP 00180249, which is a video of the Hotel Maison. So she saw all the rooms, she saw all the locations in this video during the preparation session, and it's there that she says, oh, this building is a she. Even then, she doesn't say she's detained there. So this is something that we first heard, this new material fact, was on the stand. And we submit, Your Honours, that this mutation, this evolution in her testimony must also be construed in light of other changes and inconsistencies in her account. I draw your attention to the changes in the name of her husband, the changes in the association of the group to which he belonged. And I would also like to underscore that this was a witness whose name was not disclosed to the defence prior to the trial. It was a late disclosure witness. And as we've set out in our brief, as a result of that, we were unable to cross-examine P150 and P626 on this aspect. And that shows why this aspect, the location, is a crucial aspect for her account, because there were witnesses who could clearly controvert it. And without this material aspect, we were deprived of the ability from doing so. And even today, they've referred to D202, testifying that he left each night, but he also testified at transcript 204, page 29, lines 18 to 24, when people leave the courthouse, I would personally lock the courthouse and take away the keys with me. Now, when she testified, P538 said that she was there for more than one night. She never said she was taken in or out. So it's clearly implausible that she's not there during the day and suddenly comes in just after everyone leaves each and every night. That's a clearly implausible account, and in any case, it's an account we should have had when other witnesses who could have talked about it were on the stand. So for these reasons, not only do we have no timely notice, we also have clear, concrete prejudice. And these two factors mean that you can't rely on this for your judgment. My second point is that given that she said on the stand, under oath, that she was testified at the Sha and that it was the justice, that means that you can't now refer on her statement. You can't go beyond her sworn evidence and assume or infer that she actually meant somewhere else. And that's because the statute and rules are quite clear as to when the chamber can have recourse to a written account. And this isn't one of them. Her statement's not in evidence under Rule 68, and even today the prosecutor is averring that it's not the Guvnera. So we submit that there's no basis or foundation for the chamber in its judgment to conclude that it could be the Guvnera, given her sworn evidence. So on the basis of these two factors, first, the material mutation in her evidence for which we received no timely notice, coupled with the clear prejudice given our inability to investigate or cross-examine witnesses who could have clearly controverted her account, and two, the absence of any timely or confirmed facts concerning that correlate to her sworn testimony, there's no basis to convict in relation to her detention. Thank you very much.
Thank you very much, Ms. Taylor. Presiding Judge.
Je remercie Madame la juge Prost pour sa question et naturellement je remercie les parties et les participants pour leurs interventions. Ainsi, nous arrivons au terme de la présentation de conclusions orales des conclusions finales des parties et participants. Je constate qu'il n'y a plus de demande de parole. Et avant de lever l'audience, je voudrais encore une fois remercier le parti et les participants pour l'esprit de coopération et pour la bonne entente qui a régné tout au long de ces procès. Et la Chambre ne peut que s'en féliciter. Conformément à la règle 142 du règlement de procédure et de preuves, la Chambre va désormais se retirer pour délibérer à huis clos. Les parties, les participants et le public seront informés en temps voulu de la date du prononcé du jugement. Avant de conclure notre session, comme d'habitude, je voudrais remercier les parties et les participants, les interprètes et les sténotypistes, notre public dans la galerie, notre public au loin, et évidemment nos officiers de sécurité. À toutes et à tous, je souhaite une bonne journée. Nous allons lever l'audience. L'audience est levée.
All right, we will.